Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Thank you for subscribing to my channel if you have. It always is very helpful to have subscribers and sharing my information with others. It helps people stay in their houses longer. As you know, I don't give legal advice. I'm not an attorney. I'm just a homeowner like yourself who fought my own foreclosure, and I want to help as many others as I can. So today's topic is pretty important. Let's get started. Okay, so today we're going to talk about the bank's biggest mistakes. And the Bible verse of the day is Proverbs 18:17, which says, "The first to plead his case seems right until another comes and examines him." So, what do y'all think this means? It means we need to look at everything closer and find things that you might not have seen if you didn't look twice. So, before we begin, I want to make something very clear. The purpose of this presentation is not to suggest that every foreclosure filing is defective or that every mistake will result in dismissal of the case. Courts often allow parties to correct clerical, procedural, or technical errors. Instead, today's lesson is about learning how to carefully review what is filed with the court and understanding why every document deserves close examination. So our guiding scripture today is Proverbs 18:17. "The first to plead his case seems right until another comes and examines him." That verse reminds us that the first version of events may sound convincing, but truth is often revealed through careful examination. In foreclosure litigation, that means reading every page, comparing the allegations to the evidence, verifying legal citations, checking compliance with procedural rules, and asking whether the facts actually support the relief being requested. Throughout today's presentation, we'll discuss some common mistakes. Common mistakes that can appear in high volume foreclosure litigation, including procedural errors, pleading defects, factual inaccuracies, legal mistakes, discovery issues, evidence problems, rule violations, and strategic decisions that may affect a case. We'll also look at questions that you can ask whenever a new filing appears on your docket. One of the greatest advantages available today is the ability to use AI, or artificial intelligence, as a research assistant. When I receive a motion or a pleading, I often upload it to AI and ask it to identify potential procedural issues, compared citing cases with what they actually held, point out inconsistencies, and suggest areas that deserve further research. But AI is never the final authority. Every suggestion should be verified by reading the applicable rules and reviewing the cited cases, examining the evidence, and comparing everything against the official court record. The goal is not to look for gotcha moments. The goal is to become a careful, informed, and prepared litigant who understands the importance of facts, evidence, procedure, and the rule of law. So let's get started and learn how to examine, not assume, what's been placed before the court. Procedural mistakes. These are often the easiest to spot. Failure to confer before filing a motion where required by the local rules. Missing or defective certificate of conference or concurrence. Filing in the wrong court. Missing deadlines. Improper service. Violating page limits or formatting rules. Filing without required exhibits. Always read your local rules before reading the motion. Always. Pleading defects. This is another one where they have conclusory allegations, failing to state a claim, missing required elements, standing allegations that are inadequate, inconsistent allegations. There are some factual errors. Examples: wrong payment dates, wrong property address, wrong loan number, contradictory affidavits, misstated payment history, different versions of the note, wrong plaintiff bank name in the foreclosure complaint. Here's another one. Legal errors. Ask, did they quote the case correctly? Is the case still good law? Does it actually support what they're arguing? Is the case from another jurisdiction? Did they omit important language from the opinion? Citations should be verified, not just accepted. Discovery abuse. Here's an example. Boilerplate objections, incomplete responses, refusal to produce documents, producing documents without Bates numbering, evasive interrogatory answers, and failure to supplement discovery. Evidence problems. Examples: missing business record foundation, affidavits lacking personal knowledge, hearsay issues, authentication defects, assignment inconsistencies, and undated allonges. Rule violations. Different courts have different local rules. Examples: failure to meet and confer, missing certificates, improper notice, late expert disclosures, improper exhibits. Strategic mistakes. Things that aren't necessarily rule violations but can weaken a case: ignoring strong homeowner arguments, refusing reasonable discovery, taking inconsistent positions, filing unnecessary motions that waste time or undermine credibility. For example, when I receive a motion, I don't assume it's correct. I upload it and ask AI to identify procedural defects, compare the cited cases to what they actually held, check for logical inconsistencies, and suggest areas I should research further. Then I verify everything myself against the rules, the cases, and the record. That emphasizes AI as a research assistant, not a substitute for reading the filings. Common mistakes found in high-volume foreclosure filings. This is what the other side does wrong. Wrong borrower name or property address. Referring to the wrong loan or attach the wrong exhibits. Copy and paste errors. References to another borrower, another county, or another state. I've seen lots of those. Incorrect dates. Mathematical inconsistencies in the amount claimed due. Missing pages or incomplete exhibits. Affidavits that conflict with other filings, citing a case that doesn't support the position being argued, filing a motion without complying with the court's local rules such as required meet and confer or certificate of conference where applicable, boilerplate objections in discovery that don't specifically address the required. A mistake by itself doesn't automatically defeat foreclosure. Courts often allow parties to correct clerical or procedural errors. The important lesson is don't assume that the bank's filing is perfect. Don't. Read every page carefully, compare the facts to the record, verify the legal citations, and check whether the applicable procedural rules were followed. 10 things I check every time a bank files something. For example, did they follow the local rules? Are the facts consistent with prior filings? Do the exhibits match the allegations? Are the cited cases actually on point? Are the required signatures and certificates present? Are the deadlines and service requirements met? Is the requested relief supported by the motion? Are there contradictions with discovery responses? Has the plaintiff changed its position from earlier filings? Is there anything missing that the rules require? And then there's subject matter jurisdiction. Does the court have the legal authority to hear this type of case? State versus federal court. Removal and remand. Why subject matter jurisdiction cannot usually be waived. Personal jurisdiction. Was the defendant properly served? Does the court have authority over the parties? Service defects and their consequences, guys. Venue. Here's a question. Was the lawsuit filed in the correct county or judicial district? Venue is simply the proper geographic location where the lawsuit should be heard. Here's an example. Suppose you own a home in York County, Pennsylvania, but the bank files the foreclosure action in Cumberland County. Even if the court has jurisdiction over a foreclosure case, Cumberland County may be the wrong venue because the property is located in York County. A defendant can ask the court to transfer the case to the proper county. Jurisdiction versus venue. Of course, these terms are often confused. Jurisdiction asks, does this court have the legal authority to hear this type of case and the authority over the parties? Examples. Does the court have subject matter jurisdiction? Does it have personal jurisdiction over the defendant? Without jurisdiction, the court generally cannot decide the case. Then you ask, assuming the court has jurisdiction, is this the proper location for the lawsuit? Venue is about where the case should be heard, not whether the court has the power to hear it. A simple way to remember it, think of it this way. Jurisdiction equals power. Venue equals place. Or even simpler, jurisdiction asks, can this court hear this case? Then you ask, is this the right courthouse? Now there's removal issues, the timing, federal question versus diversity, and remand motions. When a homeowner files a lawsuit in state court, the defendants may have the right to remove the case to federal court if certain legal requirements are met. Removal doesn't mean the homeowner loses, it just simply changes which court hears the case. The timing of the removal. Federal law generally requires notice of removal to be filed within 30 days after the defendant receives the initial pleading, although there are additional rules that may apply in certain circumstances. One of the first things I check is, was the removal timely? If not, the homeowner may have grounds to seek remand. And then there's federal question jurisdiction. A case may be removed if the complaint includes a claim arising under federal law. Examples include FDCPA, RESPA, TILA, Fair Credit Reporting Act, federal constitutional claims. If your complaint alleges one or more federal causes of action, the defendant may remove the case based on federal question jurisdiction. Then there's diversity jurisdiction. Sometimes a complaint contains only state law claims, yet it is still removed. Why? Because of diversity jurisdiction. Generally speaking, the plaintiff and the defendants must be citizens of different states. The amount in controversy must satisfy the statutory threshold. If those requirements are met, removal may be proper even without any federal claims. Motion to remand. Just because a defendant removes a case doesn't mean removal was proper. Ask yourself, was removal timely? Was there actually a federal question? Was complete diversity present? Were all removal procedures followed? If not, the plaintiff may file a motion to remand asking the federal court to send the case back to state court. Why does removal matter? In many foreclosure-related cases, you often see the similar sequence. Homeowner files in state court, defendant removes it to federal court, defendant files a Rule 12b-6 motion to dismiss. That doesn't mean the motion to dismiss will succeed. The federal court must first determine whether the removal was proper and then decide whether the complaint states a legally sufficient claim. Here's a practical tip. Whenever you see a notice of removal, don't jump straight to the motion to dismiss. First ask, does the federal court have jurisdiction? Was removal proper? Should a motion to remand be filed? Only after answering those questions should you begin analyzing the Rule 12b-6 arguments. Standing versus jurisdiction. This is an important distinction because homeowners sometimes confuse them. Standing concerns whether the plaintiff is the proper party to bring the claim. Jurisdiction concerns whether the court has the authority to hear the case. These are related concepts, but they do not mean the same thing. Now here's a real-world example. When a judge acts sua sponte, here we go. This is Christian Curse's federal foreclosure case in the Western District of Pennsylvania. The bank filed a motion to dismiss, and Christian filed his response, and then the bank filed a reply brief. However, the magistrate judge reviewed the docket and noticed something important. The court entered the following order striking reply brief. In accordance with the undersigned practices and procedure, a party must seek leave of court before filing a reply. Notice what happened. The judge didn't wait for Christian to file a motion to strike. The judge didn't wait for anyone to complain. The court acted sua sponte, which means on its own motion. The reply brief was struck because counsel failed to follow the judge's local practices requiring leave of court before filing a reply. And here it is, if you want to see what it looks like. So they're going to have to either fix it or forget it. And here's another case. The New York case, One West Bank, full FSB versus Tartantola, deals with something much more significant. A court sua sponte dismissed the entire foreclosure complaint, and the appellate division reversed because there was no extraordinary circumstances to justify that action. Those two examples actually complement each other perfectly. Judges have the authority to act sua sponte, that is, on their own initiative. But how they exercise that authority depends on the circumstances. Sometimes a judge may strike a filing because it violates a court's procedural rules, as what happened in Christian Curse's case when the court struck the bank's reply reply brief, for failing to obtain leave before filing it. In other situations, a court may go much further and dismiss the entire case sua sponte. However, as the New York Appellate Division explained in One West Bank versus Tantiola, the power should be used sparingly and only in extraordinary circumstances. In Tantiola, the appellate court held that the plaintiff's delay in seeking a judgment of foreclosure and sale standing alone does not justify sua sponte dismissal foreclosure action. As we conclude today's presentation, remember that the goal isn't to assume the bank is wrong. The goal is not to assume the bank is right either. The goal is to examine the record carefully and let the facts, the law, and the evidence lead you to the truth. A mistake in the pleading, motion, affidavit, or exhibit does not automatically defeat a foreclosure case. Many errors can be corrected, but by reading every filing carefully, verifying legal citations, and comparing allegations to the evidence and understanding the applicable rules, you become a much more informed and effective litigant. And always remember today's scripture from Proverbs 18:17. The first to plead his case seems right until another comes and examines him. Okay, that does it for today's episode, guys. If you have any questions or comments, you can leave them in the comment section below. If you have a question regarding your own case, you can always send me an email to foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.